Hey everybody, my name is David Jacoby with Hostfully. Very excited for you guys to be joining us for this webinar. We have some awesome folks on with us. Peter Kwan, first of all, he is a retired law professor and Airbnb superhost, co-founder of the Home Sharers Democratic Club here in San Francisco, which I'm a member of as well. And also on the Airbnb, the new host advisory board. So congratulations to Peter on that. That's very exciting. And maybe Peter, when you start talking, if you want to say a quick minute or two about what that advisory board is about, it's pretty cool and the big honor for you to be selected on that. And then also we have Brandon McKenzie, who's a former property manager and also an attorney, currently an attorney at Moss & Moss, where his practice centers on short-term rentals. He's also an adjunct professor of law at Fordham. So before we get into the exciting legal topics, I'm just going to give a little bit of background about Hostfully. For those who don't know, just a couple minutes, please humor me, but excited to tell you about it if you're not a member already. So we have two platforms, a property management platform, so that's kind of full scale to help you run your business from tip to tail. We connect to the major OTAs. We have lots of email templates and triggers, owner portal, direct bookings website, and a whole lot more. And then we also have a standalone platform for beautiful digital guidebooks. So whether you're an Airbnb host with one property or a professional property manager with over 500 properties, we can help you provide a 5-star guest experience by making beautiful digital guidebooks that you send in advance. And it basically has all the details they need to know about their trip. We won a big award in 2019, Matt Landau's VRMB Keystone Award for Best All-Around Property Management Software. And Terry White, who is the property management software guy, he's probably demoed more property management softwares than anyone else, said we're one of the best softwares, period. And speaking of awards, Gartner's sister company, Software Advice, we got the Frontrunners Award for their Magic Quadrant for our digital guidebooks. And in addition to our great software, we also have lots of reports and webinars to help you be better hosts and run your business. Our big report every year is our hospitality trends in short-term rental industry, and you can view that at hostfully.com/2020 report. We just released it last month, and it's got lots of great information about how property managers did last year, so you can see how you kind of compare against everyone. Our next webinar also, just a quick plug for that, is February 3rd, and that's about photos, how visuals and vacation rentals, or rather how visuals can enhance your revenue. Basically, better photos equals more guests and more money. And then we have lots of other reports on our website as well. Go to hostfully.com and check out the reports section. All right, so on that note, without further ado, I'll hand it over to Peter Kwan to give an overview of the evolution of the short-term rental legal landscape.
All right, thanks very much, David. I hope you can all hear me clearly. So before I start, I just want to thank David for inviting me today. I hope that I can shed some light on what's been going on in the evolving legal landscape in terms of short-term rentals. But I've known David for quite a while now. He's been a board member of Home Sharers Democratic Club, and David also runs helps us put on the Home Sharers Democratic Club annual trade show, which is on hiatus right now because of COVID, but it's an annual big party, if you like. Hundreds of hosts from all around the Bay Area come, and we have 20 to 30 different companies and services that show and advertise their business, and all these companies are part of the home sharing economy, and it's a great event where we all get together, have a great time, and learn about all the different kinds of businesses that have been generated because of home sharing. And David is the one who puts it all together. He's the chair of our committee, and without him, it certainly would not be happening every year, and certainly not as successful as it has been. David mentioned that I was recently made a member of Airbnb's host advisory board. So I just want to, as he suggested, quickly say something about it. It's something I'm very excited about. Airbnb went public recently, and before they did so, they announced that Airbnb, in appreciation and in recognition of the importance of the host community to their company, they were going to set aside a very significant parcel of shares, I think about 9.2 million shares, and when in an endowment, and once the value of those shares reaches $1 billion, then the host advisory board will consult with Airbnb in placing, using those funds in various ways yet to be determined for the benefit of the host community all around the world. There are 17 of us on the board right now, 3 from the United States. So it's very early days, and we're just starting to get the ball rolling. So please watch out for announcements, but it's something which I'm very excited about. We hope to be able to do some real good for the hosting community all around the world. But obviously, my remarks today are entirely mine. They don't necessarily reflect those of Airbnb. I speak only for myself. So a little bit of information about my background. I live in San Francisco, like David. I've been an Airbnb host for about 10 years. I live in a small 2-story single-family home, Edwardian home, in a little alley in the North Beach area. And if you know San Francisco, North Beach, we're sort of surrounded by and very close to Fisherman's Wharf, Little Italy, Chinatown, and cable cars. So shortly after starting to host about 10 years ago, I started a small group of fellow hosts who agreed to meet monthly to exchange information about hosting. Things like, insurance, zoning laws, best practices, that sort of thing. I didn't know it then, but apparently that was the beginning of the first ever host community group. We called ourselves the Home Sharers of San Francisco, borrowing the term home sharers from this new thing we were just starting to hear about, the sharing economy. We narrowly approved that name. There was a large minority of people who thought that term sharing economy was too esoteric and unfamiliar. Nobody knew what that means. Of course, these days, it's a very common phrase, very common term. But back in those early days, when we met monthly, we invited speakers from Airbnb to talk about changes to their platform. And very memorably, there was one speaker from Airbnb who came and talked about various proposals to legalize short-term rentals in San Francisco. I remember that the Airbnb speaker told us, don't worry, you can all expect the city to fully legalize short-term rentals for anyone who wanted to do so. She said, of course there'll be a permitting process, but she reassured us getting a permit would be really easy. You just go online, you fill out this form, it'll only take a few minutes, you pay a small fee, and that's it. There'll be minimal restrictions, and only the worst offenders will be bothered by the city. Well, needless to say, that didn't happen. There was a long and complicated draft law that was introduced by then Supervisor David Chu. So we at Home Shares closely analyzed it. We produced a 20-page commentary with our objections and proposal for amendments. The draft law was fought over, but eventually it was passed. Then the opposition to legalization started to happen, funded mainly by the hotel lobby. They mounted a ballot proposition to eviscerate many of the rights that the law gave us, and it sought to impose draconian enforcement provisions as well. So we fought that proposition with a small army of dedicated San Francisco hosts and a $10 million campaign funded by Airbnb. We won resoundingly, but that just started battles over amendments that was being passed through City Hall and eventually fought over in federal court. which eventually led to a settlement agreement between the city and county of San Francisco and Airbnb and HomeAway. And basically, settlement agreement was one where the platforms agreed to list only validly permitted listings, to display the license number, and to provide custom-made data on a regular basis to the city for enforcement purposes. And along the way, we also sought constantly with the new and fairly hostile city department over the way it was administering and enforcing this new ordinance. So basically, when it comes to legal regulation of short-term rentals, we've seen it all in San Francisco, and we probably saw it first. So my remarks today will focus on what I see as legislative issues that have recently arisen in San Francisco, and therefore likely, possibly, will appear in other jurisdictions as well, and what we can expect to see in the future. So initially, what we saw was that cities at the forefront of short-term rental regulations were cities with the most acute housing affordability problem. So places like San Francisco, New York, Honolulu, Miami, all those cities had very severe housing affordability problem and were amongst the first to enact short-term rental regulations. As those cities refined and fought over with platforms over the regulations, a model of regulations emerged that other jurisdictions could then copy and use as a model. So in the early days, I remember the director of San Francisco's Office of Short-Term Rentals telling me that he would get several calls and emails every day from other cities that wanted to learn about short-term rental regulations and what San Francisco was doing. So we was definitely used as a model and as an example for other cities and other local governments. The short-term rental regulation model has several components. There's permitting and registration, restrictions, for example, can you only do short-term rental in your primary residence or other properties that you own as well? Restrictions also include things like annual daily limits and even geographic restrictions within the jurisdiction. And the third element of the regulations is obviously enforcement. So these models set a precedent that made it easier for local governments to insist that platforms begin to share client data with the cities. It made it easier for those local cities to mandate that the listings clearly display valid permit numbers, and also to agree to take down listings that don't display those valid permit numbers. What we've also seen since those early days is the emergence of third-party regulation and enforcement web companies. These companies, like famously Host Compliance, they offer local governments a sort of a one-stop shop for online regulation, permitting, and enforcement. They provide these online tools for a fee, obviously. So now small cities, they don't have to set up their own departments and to hire new staff or to build new websites on their own. They can simply contract with a company like Host Compliance to do the same, and many have chosen that option. But there is good news. These models and tools means that if you are in a smaller market where there are no short-term rental regulations, or those regulations are unclear, from a host point of view, it would be advisable to be proactive and lobby for regulations that are fair and reasonable, using these existing models and tools and third-party enforcement sites. Because the alternative is to wait until there is some influx of short-term rentals in your area, and then you start to hear neighborhood and voter complaints. And when that happens, the local legislators, the local lawmakers, are understandably getting agitated and unhappy, and they are likely to see short-term rentals as a problem that needs to be fixed, or even short-term rental is something that needs to be eliminated. And when that happens, it's much harder to talk to them about fair and balanced regulations. So the bottom line is, if in your city, in your jurisdiction, there are no short-term rental regulations, a lot of hosts tell me, well, we just have to keep under the radar and let sleeping dogs lie. But my advice is don't wait for it. Start talking to your legislators as soon as possible to make sure that you can get fair regulations passed before they handle it, because it's starting to get a lot of voter complaints. On the permitting front, David, I'm not sure. Oh, yes, I can.
Do you want us to move?
Yeah.
All right.
So on the permitting front, let me talk about that first. The COVID-19 pandemic has actually dramatically shifted the market for short-term rentals. As the CEO of Airbnb, Brian Chesky, recently observed, increasingly the most popular listings on the platform have shifted from tourist cities to remote, often rural listings from places like Truckee, California, to other even more remote places in Arkansas or the South. As workers empty their urban offices because of COVID, and those workers began working from home remotely, they become short-term rental guests looking for larger properties for their families. And often they're looking for larger properties in isolated, COVID-safe or safer regions. This in turn forces more and more small towns and local governments to address concerns about short-term rentals by enacting regulations, often for the very first time. On the issue of restrictions, before Airbnb banned party homes, local governments increasingly sought to restrict short-term rentals to hosted rentals only. Like in San Francisco, there's a restriction on the number of days in which you can rent out your listing on an unhosted basis. So what we are seeing is that because of the problems of party homes, some local governments have sought to restrict or even to ban unhosted rentals. So platforms like VRBO or Vrbo, they specialize in whole home rentals or vacation rentals. So Vrbo started to begin to oppose these restrictions a little bit more aggressively, both politically and legally. One of those notable challenges in California was one that happened in Santa Monica, where Santa Monica passed regulations that included a ban on unhosted short-term rental listings. So what Vrbo did, or HomeAway, which owned Vrbo at the time, they sued the city of Santa Monica in federal court, and Airbnb joined in that lawsuit. And Airbnb and HomeAway argued in federal court that that ban on unhosted or vacation rentals was both a violation of the First Amendment and of Section 230 of the Communications Decency Act. Well, long story short, the platforms lost at the district court level, and then they appealed up to the Ninth Circuit Court of Appeals, where they also lost. So the bottom line is that this case then sets a very bad precedent for challenges to local government regulations, especially those that ban unhosted listings. And because of that case, the legal landscape is now easier for local governments to impose restrictions and to impose obligations on the platforms to make sure that only legal listings appear, or to ban vacation rentals. So local governments of all sizes can do all that now without having to worry too much about legal challenges by deep-pocketed Silicon Valley companies. So on the topic of party homes, one way of looking at Airbnb's recent banning of party homes ahead of their IPO, is that Airbnb had largely ceded that ground because of that case to local governments anyway. So it was to their advantage to get ahead of that issue as a public disclosure item. Of course, vacation rentals and whole home rentals are still available on Airbnb, and Vrbo has not banned party homes since their market is mainly whole home rentals.
Peter, excuse me 1 second. I've just seen a flurry of a few questions coming at the same time about what unhosted means. Can you please clarify that?
So unhosted means that you're renting out your listing when the home isn't present at the same time, right? So if you are renting out your entire home and you're staying at grandma's, and your guests have the entire home to themselves, that's unhosted. Hosted is your typical idea where the guest and the host are living in the unit at the same time. The host is renting out a spare bedroom, and that's a hosted rental.
So for all the property managers that are on this webinar, the properties that they are managing would all fall under the unhosted category. And
Correct.
in certain places like Santa Monica or San Francisco, there's regulations against that period.
Correct. And mostly vacation rentals, your typical idea of vacation rentals are unhosted. So there's been some recent chatter over the press about Vrbo's parent company Expedia spinning off Vrbo as a separate publicly listed company. And if Vrbo does go public, it'll be interesting to see whether or not and how they deal with this issue of party homes as being a potential area of liability. So another emerging area of restrictions is that of intermediate length occupancy. So like many other cities, San Francisco defines short-term rental as rentals of less than 30 days. And what we saw in San Francisco in June of last year was that San Francisco enacted legislation that effectively outlaws these monthly leases, more than 30 days, unless you obtain an intermediate length occupancy permit. And the legislation places a cap of 1,000 of these permits at any time. So there's a limit of how many permits there are. So there are 1,000 of them, and you have to have one if you want to rent out your apartment or your unit for more than 30 days or more. So why did they do this? The legislative intent was to crack down on companies buying up entire buildings that were meant for permanent tenants and then converting the units in those buildings into monthly leases that they rent out to visitors, usually to professional consultants on a month-to-month basis. And this happened in San Francisco. The supervisors went ballistic, and because they thought this was a terrible example of how deep-pocketed Silicon Valley companies was exacerbating the housing affordability problem by removing entire buildings, residential buildings, off the housing market for permanent tenants. But the effect of the law is that where previously there were a lot of short-term rental hosts who, for one reason or another, is not able to get a short-term rental permit or doesn't want to be subject to the short-term rental ordinance, what they did was to rent out their listing 30 days at a time, thereby avoiding being subject to the short-term rental ordinance. Because once it's more than 30 days or more, it's no longer short-term. But now, because the new intermediate length occupancy law was passed, these short-term rental hosts can't do that anymore unless they get one of these ILO permits. And a lot of them can't get these ILO permits because they're not in the downtown core area where those permits are allowed, or because they live in an older building or in a single-family home. Those permits are only given out under this law to sort of new condo buildings, by and large. So it's not clear whether or not the supervisors meant to make ILO ordinance, the intermediate length ordinance, so broad as to catch monthly hosts. But some supervisors had complained that short-term rental hosts were skirting the short-term rental law by having these series of 30-day guests, and that the supervisors regarded this practice as a quote-unquote loophole. The bottom line is that other cities where housing affordability is a hot political issue may also see the introduction of these intermediate length ordinance laws, occupancy laws, as a way to curtail monthly hosts. All right, so on the enforcement front.
Peter, excuse me, one thing I just want to say to everyone, we see your questions coming in. We're going to save the questions to the end. And if there's questions that are specific to like your city, we're probably not going to address those to everyone here. There are some good kind of general legal related questions, so we will bring those up towards the end. And just being sensitive to time, Peter, about maybe 3 to 5 more minutes, and then we'll move on to Brandon.
Okay. Great. Thanks, David. So on the enforcement front, the initial trend of local governments, including San Francisco, was to only take enforcement action on a complaint basis. That is to say that city officers would only investigate a listing if there was a complaint that was lodged by a resident, often by a neighbor, but the complaint can be lodged by anybody. Initially, that was the official position taken by San Francisco's Office of Short-Term Rentals. They assured us they would not be taking their own initiative to police the regulations. This quickly and quietly changed as elected officials criticized platforms, often only with anecdotal evidence, for allowing large numbers of unpermitted listings. This led to aggressive political and legislative pressure on platforms to require the posting of valid permit numbers and the sharing of data. It also heralded the end of a purely complaint-driven enforcement policy. OSTR officers started to employ web scraping services to root out likely offenders, and they also started to initiate their own investigations. One area to look out for in the future is whether local governments will further restrict short-term rentals to only single home operators. That is, whether to ban hosts with multiple listings within a jurisdiction. The intention here is to address both a perceived housing affordability and a neighborhood degradation issue. That is to say, hosts who buy up or rent out multiple homes in order to operate them as short-term rentals are often criticized for driving up housing costs and turning neighborhoods into areas of transient occupants rather than permanent families. Now, it's important to note that short-term rentals are often, the short-term rentals' effect on housing costs is often far less than imagined, and neighborhoods are never as stable as one wishes or dreams them to be. Nevertheless, some local governments may look at restricting short-term rentals to single home operators as a solution. Now, San Francisco is, for better or for worse, a petri dish when it comes to this intersection of technology and society. Tech disruptions to conventional economies tend to happen here in San Francisco first and are fought over here first, be they ride-sharing companies like Uber and Lyft, or food delivery platforms like DoorDash and Grubhub, or home-sharing platforms like Airbnb and Vrbo. Whereas high tech was initially seen as an economic boon, especially after the 2008 Great Recession. High tech, we saw in San Francisco that high tech really saved San Francisco from the worst of the job losses and economic decline that sent the rest of the nation to a slump. But what we've been recently witnessing is a backlash against high tech. Even though San Francisco worked out a truce between the city and the platforms in the settlement agreement, as it's known, that was the result of bitter legal battles, and the resulting peace is still fragile. The powerful forces like the hotel lobby and tenants union and hotel workers union are still working tirelessly and ceaselessly in City Hall, hiring lobbyists to pressure legislators to pass still more restrictive regulations. Progressive supervisors increasingly find that demonizing high-tech companies for social ills is a political message that resonates amongst its voters. So these progressive supervisors are responsive to those views, and what we are finding is that the forces that are hostile to home sharing are increasingly finding a friendly audience amongst our local lawmakers. To give you an example, in San Francisco, shortly after the progressive supervisors took over the board, we noticed that the hotel lobby funded a lobbyist, and that lobbyist was having regular meetings with supervisors according to public disclosure records. So as the webinar suggests, the legal landscape of short-term rental regulations is still very much shifting, and the politics is not at all stable. And unless we remain vigilant and active and get our host community groups together to present a political voice, we will likely to see further changes and restrictions appearing on the agenda of local governments. All right, thank you.
Awesome. Thank you so much, Peter. That was a great overview of trends at a high level. And Brandon, thank you for joining us. I know some information you want to talk about, a bit more of a deep dive, I think, on Airbnb and also New York. So please take it away.
Yeah, so I see, can you hear me okay, David?
I can, yes, and feel free to move on to the next slide. You should be able to.
All right, I will click over. Thank you for having me, and thank you guys all for attending. I'm going to try to keep this sort of general purpose because I know that we have participants from all over the country, potentially all over the world today, and I'll keep the remarks on New York a little bit light. By way of background, I'm an attorney at Moss & Moss. We're a New York-based law firm. I'm seeing many, many LinkedIn requests from, I'm guessing, a lot of you. So as you probably know, I've been lead defense counsel on some of the leading short-term rental related matters. City of New York v. Tominovich et al., City of New York v. 219 Avenue A. If you Google my name, you will likely see my name on those cases. Our firm also handles a comprehensive set, like quite a few transactional matters. So we do things like portfolio acquisitions, terms of service drafting, rental agreements countrywide. And we're very fortunate in one regard in that we sort of live, Peter touched on these three things, and it's sort of this policymaking aspect, like sort of the regulation, I believe it was, enforcement or restriction and enforcement. We live in the buckets of restriction and enforcement, and New York tends to be more rough and tumble than any jurisdiction in the United States that I'm aware of. So we have a pretty deep view into just how bad this stuff can get. So when we get calls from people in Nashville and they say, hey, we need our, rental agreements for our resort redrafted, we can already anticipate all the horrible things that they're probably likely to see in the next 18 months because they've probably already happened here in New York. And so what I'd like to focus on today is not just the legal aspects, but some of the things that you're going to see in the platforms themselves So just to start, one of the things that I want to focus on that's fairly new, I think it's been in about the last year, is Airbnb's off-platform policy. Because we're finding that more and more enterprise PMs are not even aware of this, which is frankly, when you have 300, 400, 500 listings plus, it's surprising to me that people wouldn't be keeping abreast of significant updates to terms of service. Now, Airbnb's off-platform policy is in a nutshell, if I had to synthesize it, reduce it to one sentence, is keep all your communications on Airbnb in the Airbnb chat. They don't want people going outside circumventing the Airbnb platform. And that's very likely for obvious reasons. It's if you're initiating direct bookings, Airbnb is not collecting a fee on those transactions. So understandable that they wouldn't want that. But there are other reasons even beyond that. If you're texting with a guest on WhatsApp and there's a resolutions claim from either side, whether it's PM or guest, Airbnb, their CS team doesn't have insights into that because they're not seeing those communications unless you're screenshotting them and sharing them. So it's actually a good policy to keep things on Airbnb, assume Airbnb is reading everything that you're writing, seeing photos, and conduct yourself accordingly. So some of the things that they're off platform, I'll just burn through these because they are in the slides. Some of the things you should not ask guests for. Don't ask for guests for reviews. Don't say, hey, write a Google review of our company. Don't ask them for their email and phone number. And there was a terms of service update just a few days ago, and I believe they changed this. I think they tweaked the language to say prior to booking, because phone numbers, as far as I can tell, are automatically disclosed now once a booking is confirmed. But if you ask beforehand, you're kind of signaling to Airbnb, hey, maybe I'm trying to go around you and initiate a direct booking. Don't try to facilitate direct phone calls to your guests. Again, don't use non-Airbnb or third-party apps or websites. This is a little more expansive. I've seen this applied now to things like smart lock apps. So if you use like an August lock or something similar, and you tell your guest, hey, you have to download the August app, that can technically be construed as a policy violation. Again, one thing I think they did change recently is you can't ask for a government-issued photo ID. The language now says prior to arrival, and there's a little nuance in here that you guys should be aware of. In theory, could you ask them for it when they get there? Maybe. Do they have to give it to you? Probably not, and you'll see why on the next slide. And then contact info for background checks. Now, this one's interesting, and I know this applies to more jurisdictions than New York. One thing I'm seeing now, Peter mentioned these non-host homes, people who are enterprise professional PMs who are, making money off rental arbitrage, things like that. These guys have more exposure, more risk, and there may be some of you guys who are on this right now who fall into this category. In New York here, we currently have an eviction moratorium. And there's also a data sharing agreement that I'm going to get to a little bit later, where people are starting to shift more to 30-day plus rentals. Well, there's a risk incident in doing so. If I'm a guest and I book an Airbnb, like this lovely one that I'm in right now in Brooklyn, if I book an Airbnb in New York and I stay for over 30 days, arguably I could have established tenancy. And that affords me certain legal rights. So let's say hypothetically, my Airbnb host tries to change the locks or lock me out. That could be construed as an illegal lockout, and I could bring a court action and say, you have to let me back in. Well, if I'm there for over 30 days and there's an eviction moratorium and they can't evict me and they can't lock me out, it's not beyond the realm of possibility that I could just say, hey, look, I'm just not going to pay rent, and I'm essentially going to squat until the eviction moratorium is lifted, and you can take me to court 6 months from now. So I understand the impulse of a lot of these professional, there are a lot of real estate brokerages, things like that, who will say, we want you to sign a lease agreement. We want to run a TransUnion background check on you. That is absolutely not allowed under Airbnb's terms of service. Now, I'm going to jump to the next slide because, Elizabeth host contract. Sorry, I'm going to jump 2 slides ahead, or maybe 3. The short version is, there's a practical note here. Yes, you shouldn't do that. And it is kind of a bad guy move. If you're thinking just in black and white terms, am I doing the right thing? Probably shouldn't be fishing around and getting your hands on personal sensitive data like people's social security numbers and things that could expose you to liability if they were leaked or hacked from your company, or expose yourself to liability for things like GDPR violations. For those who know what that is, it's a European data protection law. If you're collecting information on European guests, it's probably not a good idea to run background checks. I get the impulse. In a practical sense, Airbnb has drafted its terms of service to give themselves broad latitude. They use the word may a lot. Airbnb may suspend your account. Airbnb may terminate your listings and reservations. That's not necessarily saying they will. So if I'm a guest and you try to run a background check on me, or you say you need to give me your photo ID or I'm not letting you check in, me personally, I'd be up in arms. I'd say, over my dead body, absolutely not. And then if I make a call to Airbnb, you have to cancel that reservation. You get hit with host penalties. Maybe you lose super host status. Maybe your calendar is blocked. Maybe it's worth it for you if you feel that way. And if I'm an angry guest and I call Airbnb and say, they're violating your terms, you have to kick them off. They don't have to. They may. And Airbnb, in my experience, looks at these scenarios holistically and they say, okay, this is a company with 300 listings and they are generating X amount of revenue for Airbnb. This is one complaint. Should we do anything? And I have been informed by Airbnb CS reps that they actually don't respond to those complaints. They don't take action unless they have at least 2 complaints, even in cases where there is very clear, obvious illegal activity. So, it's a balancing act, but these are all things that are worth keeping in mind for those of you who are individual hosts, those of you who are PMs. There are consequences. I always say err on the side of do the right thing. But if you are in this bucket where you're doing things that may be a little bit in a gray area, it's not to say that you don't necessarily have time to right the ship and, bring yourself into the closer compliance with Airbnb's terms of service. So that's a plus. Now, this brings me to my next subject, and this is something our firm has done a good bit of in the last, I'd say, year or so. Airbnb has a policy now where I know some of you guys probably are using a platform like Hostfully and you are channel managing and you're listing on Vrbo and Airbnb and Booking.com and various other platforms. And you may automate distribution of rental agreements or other agreements. I'm seeing a lot of COVID liability waivers right now, which is, I want to say surprising, a little unsurprising. With host contracts, Airbnb has a policy where they say, not only do you have to disclose the existence of the contract, and there are certain times where you can have it signed. You can say, my HOA, in order to Airbnb, requires it. Here's our HOA rules. They say, you have to sign this or you can't stay. Airbnb has carve-outs, and that's allowed. There are things like that where it's okay, but you can't just say, we have a contract. You can't just reference it. According to Airbnb's terms, you actually have to disclose the terms of the contract, meaning take the whole thing. If it's 50 pages, if I recall correctly, I don't think there's a character limit in the house rules, copy and paste the whole thing. Or copy and paste a bunch of it and take out, things that aren't necessarily terms. So personally identifying information, what your business's address is. If you think you make the argument that that's not a material term, you can carve it out, but you still have to disclose the terms. If you don't, the guest is under no obligation to sign it. And again, you end up in that situation. Maybe you end up with a block calendar, host cancellations, ding on your record where if a few of them come in, Airbnb can cancel your reservation, suspend your listing, cancel your account. So this is one of the things our firm has been tasked with lately. We have PMs, resorts contacting us saying, will you redraft our terms, our guest agreements in a way that's user-friendly where we can drop them right into our Airbnb listing. Because if you're afraid to do that, if you're like, I don't want guests seeing this, you probably have to take a hard look in the mirror and say, like, am I the bad guy? Am I doing something wrong? If the terms are so onerous or one-sided or us favoring or potentially unenforceable, because that can happen, if they're too one-sided, if you say, these are so bad that I'm embarrassed to put them in my own listing, you should probably take a hard look at your own business. But a good thing to be aware of, if you're not afraid of that and you have simple terms, there's a simple way around it. Put it in your listing. Just disclose. Err on the side of disclosure. Now, oh, I got a weird echo. Bear with me one sec. I'm going to reload.
Okay, maybe while Brandon is coming back, Peter, there's some good questions that we've seen. There was one, I want to find it. Hey, Brandon, I was just about to ask a question while you were off, and maybe you and Peter can comment on this, and then we can go back to what you were saying. The question was regarding Texas. I can't find it easily now here. But it was regarding Texas. Okay, contrasting the Santa Monica legal precedent I heard that the Texas Supreme Court has actually decided it was illegal to restrict homeowners from doing STRs. So can either of you comment on that? It seems like different states are having different opinions here.
I'm not actually familiar with that decision. Peter?
I did read something about it, but I don't know about that case in detail. You know, my remarks, of course, were general. Of course, there are going to be exceptions. And there are going to be states with very strong private property laws and even legislatures that place a lot of importance on private property rights. That's going to try to protect homeowners from laws that take away the ability to do things on their properties. So, for example, in Florida, I think there might have been a question about that too. The legislature in Florida have tried to pass a law that will ban local Florida governments from imposing a short-term rental ban. I don't think it passed the first time. I think there was an attempt to pass it again. But my understanding is that that hasn't been successful. And as far as the Texas decision is concerned, I don't know too much about it, but I thought that was it at the lower court level. So, and it's in a Texas court, so it's not likely to have much or any precedential value outside the state of Texas, even though Texas is a very big and important state.
Mm-hmm. Great. Thanks,
Cool.
Brendan. We hear you clearly now, so
All
go
right.
for it.
Yeah, I believe brevity is a gift, so I'll wrap it up and try to leave time for Q&A. So I know that I've been made aware that many of you guys are using the Airbnb professional hosting tools. So I do want you to be aware, these are the carve-outs on this slide that say you can use an Airbnb email alias. And I don't know how many of you guys use an Airbnb email alias, but if you do, here are some purposes for which you can use that alias. That does not absolve you of the responsibility to abide by Airbnb's off-platform policy. So just because you can send a rental agreement using an anonymized email doesn't mean you should, and if you do, you still have to comply with the other policies. So there's a little patchwork of overlapping policies, and you should be mindful of all of them. So again, practical note, Airbnb can, they can do whatever they want. If you're making them enough money, it's not to say they will, but why put yourself in a precarious situation if you can avoid it? You know, my mom used to say to me when I was a little kid, she'd say, always do the right thing. And if it is absolutely impossible to do the right thing, do the next right thing. So I'm just going to touch really quickly on New York because I know this doesn't apply to all of you. This is what we are up against. A lot of New York hosts, and this isn't even all of them. You know, the cases that I have in New York State Supreme Court, those are public nuisance, deceptive trade practices, consumer protection law cases. There's a whole patchwork of laws. And a lot of people will look at these and say, oh, I'm in compliance with the multiple dwelling law. I'm not listing my Class A apartment as an entire home for fewer than 30 days. Therefore, I'm fine. Not the case. This is like what we're looking at. All of these things overlap with one another. It's like, you know, just because you're not violating the multiple dwelling law doesn't mean you're not violating another provision of the administrative code. So whatever your jurisdiction is, you know, it's always a good idea to consult with competent local counsel and say, hey, what, you know, you don't know what you don't know. What are my blind spots? I think I'm complying with one law, but are there 10 others that I might have as blind spots and risk factors? So I encourage people to do that in their local jurisdictions. Talk to a competent attorney. It'll probably be worth the not modest consultation fee or the opinion letter. So New York, we have this fun thing now. For those of you who are here, for those of you on here who are in New York, in the city here, Airbnb and HomeAway were engaged in pretty brutal litigation with New York. There was some federal litigation a couple of years back, probably somewhat similar to the litigation that Peter had referenced, where New York basically said, we want all your host data. We want to know who everybody is, where they are, names, addresses, phone numbers, payouts, anything and everything. And they fought it tooth and nail, and ultimately they settled. And part of that settlement was, as of January 3rd, just a couple of weeks ago, Airbnb will now start turning over to the city of New York on a quarterly basis all of this information about hosts, with a few carve-outs: name, address, phone number, email, profile ID, URL, payouts, anonymized identifier for payout method. They're not going to transmit full bank account numbers, for everybody. And this is the sort of stuff that goes over there. It's not just the host information, it's also the listing information. So now they have essentially a laser, a precision targeting system to say, you are violating the law, you are violating the law, you are violating the law, to ease their investigative burden to go after hosts aggressively. And when you're looking at what I understand to be about a $15 billion budget shortfall in the city, likely caused in large part by COVID, and you are looking for cash, issuing summonses and initiating lawsuits against enterprise PMs and even mom and pop hosts can be quite lucrative. So for those of you in New York, be careful out there and do what you can to bring your listings in compliance with the law. These are the exemptions. It's if you're renting for fewer nights per quarter, if you have a private room with 2 or fewer guests, your data should, in theory, not be transferred. And that's us. I am seeing still, I cannot tell you how many LinkedIn notifications I'm getting. David, if you'd like, you are more than welcome to share my email address. I'm happy to share my contact info. I'm an email junkie. I much prefer it to phone, LinkedIn, anything like that. So do feel free to get in touch. But know that if you message me on LinkedIn, it may take a while.
Such great information. Thank you, Brandon. Why don't you just quickly say your email address right now, too, and we'll also follow up and send it to everyone.
Sure. It is B. McKenzie. So Bravo, Mike, Charlie, Kilo, Echo, November, Zulu, Igloo, Echo. So B. McKenzie at Moss and Moss, which is MOSSANDMOSS.com.
Awesome. Okay, so I want to be sensitive to time, and a lot of questions came in. Again, there are a lot that are specific to the certain city that they're in, so I don't think it makes sense to go through those, but there are some really good high-level ones as well. And I want to kick things off for this kind of lightning round. So Peter or Brandon, what do you see as the most important change in law affecting short-term rentals?
Oh. I got a bunch. Peter, you wanna field this one and then I'll weigh in?
Yeah, go for it.
I think from a legal perspective, one of the things that we're seeing, so, Governor Cuomo released a proposed budget, I think it was a day or two ago. And one of the first things he said is, look, there's a reality on the ground in that short-term rentals are here, legal or not. And it's a missed opportunity not to tax them. Now, this has been something that's been battled back and forth. Airbnb has lobbyists on the case and has for years saying, just tax us. Let's, structure this so everybody can play nice in the sandbox. We do it legally. It'll be a windfall of cash for the state and the city. And Cuomo's starting to come around saying we should apply sales tax or use an occupancy tax or both. And I think that's sort of the biggest thing that I think will come down sort of the pike here is people look at this and say, how do we turn this into a revenue opportunity without simultaneously encouraging what municipalities view as what this bad behavior that Peter indicated before. It's, when you see a city and somebody takes entire buildings off the market and turns them into what look like IKEA showrooms and reduces the affordable housing stock, that's not good for anybody. Maybe short-term for Airbnb, but even for Airbnb, that's not good for them because it makes them seem like bad guys. So I'd say sort of legal developments are broader, more consistent regulations. One of the things that I think we talked about before we got on this call is a lot of these governments talk to one another and they push for, most favored nations treatment and the same deal or the better deal than the last guy got. So if London says, hey, we're going to collect this percentage of tax and this limitation on nightly rentals, and then Airbnb moves on to say Amsterdam and they say, hey, will you guys play nice in the sandbox? Amsterdam may very well turn around to them and say, we want the same deal or better that London got. And I think over time, what you're going to see is more uniformity as this sort of body of understanding grows. I mean, I'm sure Peter can speak to this much better than I can, but when San Francisco started with its registration regime, it was a nightmare. It was an absolute spaghetti bowl. Nobody could make heads or tails of it. Completely imploded. But over time, it evolved, and it's part of this learning process of what works, what doesn't, what benefits everybody, all stakeholders involved. So guests, hosts, the local municipality, taxpayers. Like, how does this contribute back to local communities? And I think you'll see over probably the next couple of years a shift in that direction of how do we make this a win for everyone involved.
Yeah. So to answer that question, David, I would say there isn't like one specific legal change that everybody has to be scared and worried about. I think, in fact, the thing that keeps me up at night is sort of death by a thousand cuts. That you have jurisdictions and local governments who want to either shut down or severely curtail short-term rentals. They know they can't do it in one fell swoop, so they start imposing, higher fees. Fees in San Francisco have gone from like less than $100 to $250 to $450. You're going to see higher penalties for infractions. You're going to see fewer and fewer days you're allowed to do short-term rentals in the year. And the one thing that I'm kind of scared to even mention, in case any of these city officials are listening to, I worry about ADA. If lawmakers start insisting that all listings be ADA, Americans with Disabilities Act, the requirement to have wheelchair ramps and things like that, if they start insisting that every single short-term rental listing is compliant with the American Disabilities Act, to comply with that will put, I would say, the vast majority of us out of business.
Yeah, there's another thing too that I think we touched on briefly before this call, which is Section 230 of the Communications Decency Act, where this has been in the news a lot lately. You guys may have heard of it, but there's a certain amount of insulation that's afforded to platforms. So if YouTube, for example, exists and someone uploads copyrighted material, YouTube is not directly responsible for the actions of the publisher, the person who did the illegal act. And I think you're running into gray areas with a lot of big tech companies now. It's, well, where should the line be? Should there be a line? Should this shift, where a platform, say like Airbnb or Vrbo, has actual knowledge and it's traceable, and they're like, there's proof that somebody is doing something that is patently illegal on your platform. To what extent should those platforms bear responsibility or the legal burden of those actions? And I think that's sort of an open question that people are looking at now. I don't know that anything will necessarily change overnight there, but it is a topic of conversation.
Especially if they are taking the financial transaction, if they're actually doing the financial transaction or involved in that. I know that added a piece of complexity to the consideration. But thank you guys. So we've run up on our hour.
You guys have any curveballs for us?
There's still a few other questions. So, everyone who wants to hop off, thank you for joining. You're welcome to. But Peter, Brandon, if you don't mind, maybe we'll just tackle a few more questions. Maybe we'll tackle a few more questions. We could hear you, Brandon.
Lost audio. I think David's reconnecting.
Can you guys?
I am seeing quite a few questions coming in now.
Can you guys?
I'm going to give David a minute to reconnect.
Yes, we can hear you.
Okay, thank you, Pedro. No, people can hear me. I'm going to go for this question. Brandon, hopefully you can hear me. Peter, maybe you can. Speaking of trends, are there any trends or regulations popping up related to vacation rental owners operating under an LLC versus a sole proprietor? Do you know anything about that, Peter? And hey, Brandon, I'll repeat that question. If there are any trends related to operating under an LLC versus a sole proprietor?
I'm seeing one on the litigation side, and that is a lot of hosts mistakenly believe that an LLC affords them unlimited protection. And I should qualify this and this entire talk by saying, while I am an attorney, I am not your attorney. This is all information. None of this is legal advice. So probably should have said that at the outset, but just to be clear, a lot of people say, oh, what if I have an LLC? Doesn't that afford me liability protection? Am I safe, right? If a municipality comes after me because I'm doing something illegal, or if a guest, has a slip and fall and breaks his or her neck and they sue me, am I completely covered? Not necessarily. For those of you got other attorneys on here, or maybe law students, I shouldn't have to tell you about piercing the corporate veil. Sometimes there are ways to get through it, especially if it's just a shell that's designed to be a barrier, but the LLC is essentially indistinct. If all the money passes through and goes right to you, and it's just a wall, that may not afford you protection. More importantly, what I see is I go through reams of documents, subpoenas from the city of New York that just, data point after data point after, I mean, we're talking thousands and thousands of pages of records. And people think, oh, because I put my Airbnb listing in an LLC, if somebody wants to enforce laws against me and they come after me, they'll have trouble finding me. No, they won't. They have all sorts of other things, probably the most obvious of which is your IP address. If you log in from the same device or the same phone or computer, or use the same phone number, or have the same last 4 digits of a bank account, or have a government issued photo ID uploaded to a site, it's not hard for a tech company or a well-funded municipality to connect those dots. So, between an LLC and just doing it as a solo, are there certain advantages to have an LLC? Sure. I'm not a tax lawyer. I'm not an accountant. This isn't tax advice, but some of you may be aware of a way to take a 20% deduction off of LLC earnings versus individual. That's great come tax time. From a legal perspective, it's questionable. Every business is different, and it's going to be unique to how yours is structured as to what benefits a corporate structure affords you.
In San Francisco, the short-term rental regulation applies to operators, and the definition of operator includes both natural persons and corporations. So I don't think having a corporate structure is going to help you in terms of not having to comply with the regulations. Could you own one property with one LLC and have another property owned by another LLC, and sort of operate multiple short-term rental properties that way? I guess you can try, but I think it would be pretty obvious when you do your reporting and applying for the permit, and it's very easy to see who the shareholders and the board of directors are. So I think that any court wouldn't find it very difficult to pierce the corporate veil and see that as a sham. So, yeah.
All right. Another question. So this is with regards to professional property manager. So unhosted stays. Can either of you give an example of a city or town that has sensible legislation for vacation rentals, again, in which it's not the host is not the main residence? So for property managers out there, what's a good kind of benchmark city or town where it's a good compromise all around, people are happy with it? Bueller?
Peter, I feel like this is your bread and butter, huh? I'm a janitor with a law degree. I clean up people's messes when it's too late.
I'm kind of the same way. I just read out all the problems, and nobody ever contacts me and says, "I love
this is great.
My city regulate short-term rentals."
I mean, and the only people who are proactive, it's good to see as many people on this webinar as I see today. It's actually very encouraging, because most of the people that hire our firm, there's no way to sugarcoat this. Legal representation is a luxury service. It costs money. So most of the people that hire us for proactive steps to protect themselves proactively are enterprise level. They'll be resorts or PMs with at least a couple hundred listings, or they're doing M&A work, portfolio acquisitions, arbitrage, master leasing, purchases and sales. And they want to invest to protect themselves because their exposure is greater. I'd say a lot of the people that we encounter who are like, oh, I have 5 Airbnbs or 15 Airbnbs, are more inclined to roll the dice and say, let the money keep rolling in, and it's not a problem until it becomes a problem. Which means by the time it ends up at our office, usually it is a problem. So for those of you who are looking, I like this question. I like the fact that somebody's being smart, saying, where's a good balance? Where is it safe? Research those markets. I can't remember where I saw it, but I had it in my files, and I'll see if I can dig it up, maybe outdated. But there is a one of these software companies, it might be a channel manager like Rentals United or something, that put together a list of, they try to keep it updated. It's like, hey, here's kind of what regulations look like here. There's a registration regime, things like that. I always think that where regulations are more settled, even if there's some unfavorable things, it's like, oh, you have to pay 6% tax or 8% tax. Paying 8% tax is better than a lawsuit. So, look at places where the law is a little more settled, and you're less likely to run into trouble because it's predictable. You know what you're up against, and you can work around it within defined parameters. Versus, New York, it's the Wild West out here. It's everything's illegal. Take your best shot, roll the dice, and then end up in my office. Not a good way to be.
Yeah, go on.
I think one of the reasons why there isn't one best model is because all cities are different, right? Mm-hmm. So if you are a city with a huge housing affordability problem, you're going to have one set of laws that'll fit you. But if you're a city that is a ski resort city that is used to having it relies on transient visitors, you're going to have another set that'll suit you better. So there isn't a one-size-fit-all model, really.
Mm-hmm.
All right.
It's funny. I see all these people now in New York in particular, and I hate to keep it focused on our jurisdiction, but people are getting creative with COVID now. They see this, all right, I'm going to get in trouble if it's 30 days or more. So again, this is one of these things, talk to local counsel, find out what laws apply to your listings. They will take, say, a 3-bedroom New York City apartment and rent out each room individually. In complete disregard of the fact that may convert it into a single room occupancy that is against the zoning of the building and also totally illegal. So before you get creative, talk to a lawyer in your local jurisdiction, somebody who knows, somebody who understands building code and zoning and whatever your local regulations are. Pay the consultation fee, pay for the opinion letter, because I'm betting dollars to pesos it will pay dividends in keeping you safe or helping you stay on the right side of the law. And that is always the goal. Stay on the right side of the law.
Couple more questions, then we'll wrap up. So this one's for Brandon. Has anyone tried to argue that Airbnb's off-platform policy is an unlawful tying policy?
David, I just lost you, but I think I got the question, and I think I can see it in here. Has anyone tried to argue that Airbnb's off-platform policy is an unlawful tying policy? Not that I am aware of. And, Airbnb's off-platform policy, it gives them broad latitude. It's just, hey, if you do this, then Airbnb may, in its discretion, do something else. It's if you try to capture somebody's email address for remarketing purposes, we could theoretically suspend your listings. In practice, I couldn't tell you. I can't see the data. I have no idea how frequently that's happened. And again, let's think about this logically. What are the circumstances in which that might happen? Let's say I go to a guest and I say, hey, can I please have your email? And I'm sweet as apple pie in motherhood. And I say, can I have your email so I can send you a house manual? Oh, yeah, maybe some small percentage of people will be uncomfortable sharing their email. Most of them will be like, great, I'd love the house manual, and never think twice about it, never complain to Airbnb, and nothing happens. And maybe Airbnb doesn't even take notice or suspend your listings. I don't know that it escalates to that level with any frequency. That would be a good question for Airbnb. And Peter, maybe next time you're at a board meeting, you can ask them if it piques your curiosity. But no, to my knowledge, that hasn't come up. And it's a May. So there's a little balancing act in there.
All right. And yes, that's related to another question in general about, is it a mistake to turn guests into repeat customers that come back directly? So I think just to clarify what Brandon said, actively soliciting them is against Airbnb's terms of service. But if you are promoting your brand within the property and then they contact you directly afterwards, that is okay. So Brandon, I was just saying it's against the terms of service to actively solicit a guest to book directly with you. But if they are in your listing and you're promoting your brand in the listing and then they reach out to you directly in the future, you haven't solicited them, then that should be okay.
As far as I know, that doesn't explicitly violate any of Airbnb's terms or policies. So yeah, you're probably okay there.
All right. Great. Well, this was wonderful. We're well over time. We still see a lot of people hanging on. So thank you for spending some time with Peter and Brandon. Brandon, thank you very much for all your expertise. Some general questions too that we will follow up, and everyone will have the slides in this recording will be public, so you guys can refer back to this. We'll also follow up with Brandon's contact information, so you can contact him directly if there's any specific questions. I see you have some city-specific questions, Brandon, your way. And once again, thanks for attending this webinar sponsored by Hostfully, and we'll hope to see you for our next webinar, February 3rd, with regards to photos. Thank you, everyone.
Take care. Thank you, David.
Thanks, David.